Council, are you ready?
My Lord, for our part, you asked for the question of costs.
Oh, yes.
From our part, to date, it's 716,000 US dollars.
Thank you. Yes, Mr. Mayor.
We see it rather differently to the way put by my learned friend. We say that this application by the bank is just another unattractive attempt to avoid liability for the improper conduct of its agents in Dubai towards my client in 2007 and 8. I ask your Lordship to remember how Sir John Chadwick characterised the 2007 conduct of the bank and its Dubai subsidiary in 2000. In that, your Lordship will find in Bundle 8, at the very back of Bundle 8, page 4052, at paragraph 432, Bundle 8, divided 75, page 4052, last page. Just remind yourself of paragraph 432, you read that yourself. What he found there was the bank itself was operating in Dubai as a bank, mis-selling products without a license. It's hardly credible, we say, from a supposedly reputable Swiss bank, or incredible but true. Now, Sir John Chadwick also found that the bank's Dubai subsidiary forged internal documents to justify the mis-selling. The Lordship might find that at volume 9. Divided 78. Divided 78, page 4227. This is a cost judgment to John Chadwick, in which he inflicted indemnity costs because of this very fact. The Lordship just reads to yourself paragraphs 17 and.
Do you say 4227?
4227, please. Beginning at the bottom, paragraph 17, and paragraph 18.
Yeah.
Deliberate falsification of records in order to deceive the regulator. Now, instead of facing up in 2008 or thereafter promptly to their failures and seeking to compensate my clients properly or at all, the bank, and indeed the first defendant, fought tooth and nail to avoid liability for any loss whatsoever, resulting in many years of this court's time taken up by the defence of those proceedings. That led only to Sir John Chadwick's devastating liability judgment in 2014, and indeed your Lordship's own judgment on liability in 2016 in the Court of Appeal. In your Lordship's case, you will recall in particular the sheer volume of misconceived attacks on the judgments of facts you had to deal with. Now, even after having judgment found against it, the bank, together with the first defendant, fought tooth and nail, again, not to pay any sums immediately ordered. It appealed the subsequent quantum judgment. And even when, after all that, when the claimants emerged with a further judgment for 35 million against the first defendant, its subsidiary, the bank allowed the defendant to go into liquidation. This was in, I think, May 2016. So after these proceedings had been issued, he allowed him to go into liquidation rather than step in and pay us those losses itself as its parent. And that, of course, after the fact that these proceedings were issued, raises questions about why that happened. And that is the fact of the bank of D1 being in liquidation is the reason why they're not so far being pursued against it, because of no merit, is because it's in liquidation. Now, regrettably, in these proceedings, we say the bank has not turned over a new leaf. In these proceedings, which arise out of an effective finding of dishonesty against an agent of the bank in Dubai in August 2007 by Sir John Chadwick, the bank again had not apologised profusely for their agent's dishonest statement and promptly sought to ascertain and pay our reasonable losses arising from such dishonesty as you might hope. Instead, they have yet again, put neutrally, chosen the path of least credit. In that respect, faced with these proceedings, after we served our particulars of claim on the 9th of January 2017, the bank obtained 2 extensions of time to serve a defence, one from us on the 2nd of March and one from the court on the 16th of March. The latter order is at 1/13. Both on the basis that they needed a long time to respond to a complex particulars of claim. But they never, in fact, of course, served that defence by the eventual 1st of June date that they got ordered, and have still not done so 12 months on. My Lordship, my learned friend said, oh, well, we always said that we might issue a strikeout, but what wasn't shown to Your Lordship, and I think I'll do it by reference to the evidence before the court for the court extension, which Your Lordship will find in Bundle 1, divided by 23, at page 262, which is the evidence of Mr. Abbott. And while it is, as the first witness stated, Mr. Abbott, beginning at page 258, while it is correct that the application for extension time was made without prejudice to applications the bank might make for strikeout, Your Lordship goes to the paragraph 18. What they're seeking is I think it's over into the date sought for the extension was at that time, I think, something like 5 months. The extension requested was on the basis of matters set out in paragraph 18, the length of that. And Your Lordship, you read to yourself 18A, B, C, D, E, F, G, and onwards and H. They're all about having to understand this complex particulars of claim and also how to serve a proper defence to that. And it's only, of course, obliquely mentioned in G, the question about reviewing the matters of issue estoppel of Sir John Chadwick and what matters they might arise. Now, we didn't get it, so we say getting such a long extension and then simply on that date not serving defence, but instead ordering that issuing a technical strikeout is not attractive, and this delay matters enormously. We say it is interesting because, of course, this morning Your Lordship heard how my learned friend took a point about the issue estoppels. He said, in fact, we'll be saying that they're not issue estoppels. That's the very first time we've heard that, my Lord, that they're not issue estoppels. There's no defence served. It's not mentioned in the evidence in support of his application. It's not even mentioned by my friend Skeleton. So it explains, I think, the difficulties in that regard of not having a defence. Anyway, it's not suggested, and still not suggested today, that they have a defence on the merits to liability for our new claims. So it's a technical defence, again. Now, not only is their technical claim for abuse of process, we say, wrong, for the reasons that I'll come to, but it's a very unattractive claim to make that a claim should have been brought in, these claims should have been brought in the 2009 proceedings, when they had previously resisted the introduction into those very proceedings of only a very small part of the losses claimed here, as they would have disrupted those quantum proceedings and made them, disrupted them. Your Lordship will just pick the defendant's skeleton up on this point in January 2015. That's in bundle 9. Divider 90. Page 4565, and this opposition to our attempt to get some of these losses into the earlier proceedings. And your Lordship, just read paragraph 13 on page 4565, 13 to 13.2 to yourself. Lordship see at 13.1. It now says it's simply too late to bring these claims into these proceedings. Somewhat different to what my learned friend is saying now. At 13.2, to bring them in would require extensive further distillation of expert evidence. It would require more time. Too late for all of this to occur. Can't be dealt with in the current fixed quantity hearing. He said it's completely inconsistent with what's being said now. It's also unattractive, we say, that the defendant has not produced any evidence that the bringing of these claims in these new proceedings has caused or will cause the bank's specific material prejudice, although it's a requirement set down by the Court of Appeal that they do so, and I'll come on to that. Indeed, in a counterfactual situation, we say the bank is in materially no worse position now than it would have been, even had these claims been introduced in late 2012 or early 2013, just before trial. And that alone is fatal to the bank's application, as I'll explain in due course. The truth is that this application is not made because the bank is being abused or harassed, but because the bank hopes again to avoid liability for its agents' actions in 2007. And even if it does not succeed in getting these proceedings struck out, it knows that this application would result, and has resulted already, in yet further delays to our attempts to get full compensation for the bank for what happened in 2007. Now, my Lord, in terms of the order of issues, I'm going to address them in the following order, Your Lordship's approval. I'm going to go through the old claims, the judgments, and the new claims to pick up a number of issues addressed by my learned friend yesterday and today, including to show that while they are plainly quite different claims, the dishonest statement was of great relevance to the defendant's defence of the claimant's claims below, hence the time devoted to it by them, and two, how the 2013 trial has helped narrow the extra work to be done in these proceedings. Then I'm going to look at the law of abuse, particularly picking out some points helpful to us. My own friend did not quite address these, we would say, comprehensively. Then I'll deal with could, then should, unjust harassment, overall abuse, and I'll pick up limitation at the end. Obviously, my submission, oral submission, will be in addition to our skeleton, because I won't have time to cover the whole all of it. Now, as regards the old claims, although there are common issues, it is obvious that the claims made in 2009 and the 2006 proceedings are essentially different. The 2009 proceedings address whether or not the bank and its Dubai subsidiary mis-sold products to the claimants in June, July 07 and then February 08. In February 08. The Lordship conceded, where it's set out, most clearly in the claimant's skeleton for trial at bundle 4, divider 60. Page 1838. Paragraph 120, he sets out the heads of claims at 120 and then the categories. And your Lordship will see the category at page 122, paragraph 120 is the regulatory claim, and that is whether whether D1 breached its DFSA obligations by taking on the claimants as clients, selling them unsuitable products, dealing as an agent for the bank. Paragraph 146 to 148. The category 2, contractual breach of duty claims against D1. Those claims are about whether the defendant D1 breached its contractual or statutory duties to the claimants by providing inappropriate advice to the claimants when the claimants were contemplating buying the products. 159 to 165. Category 3, regulatory claims against D2. Those are whether D2 was carrying on a financial service in Dubai through D1's employees in the way set out in paragraphs 163.1 to 7. Paragraph 194. You will see the misrepresentation claims against
Paragraph what?
194.
I don't agree with that.
How
No, it's right here. Trying to things. One article, thank you. Yeah.
194, the misrepresentation claims against the second defendant, whether they were liable in misrepresentation, certain pre-contractual representations made by the first defendant's employees when selling the second defendant's products, and then quantum dealing, causation and quantum thereafter, 198 dealt with briefly. In summary, all the claims, without exception, concern the defendant's responsibility for mis-selling the claimant's unsuitable financial products and the consequences in causation and quantum terms of that. His claims alone, the August 07 dishonest statement, was not relevant. However, the August 07 statement, the dishonest statement, featured at trial, the conversation on the 15th of August, and hence featured in the judge's liability judgment, because it came to be part of an important issue raised by the defence, namely whether my client knew all about the risks of the leveraged products sold to the claimants, including the risks of margin calls, as he had devised the leveraging strategy. The argument going that if he had known of such risks, the claimant therefore could not claim that he was sold unsuitable products, nor that, in causation terms, he would not have bought such products had he known of their risks. The August 07 conversation was of significance to this issue, because if he was told of the margin call in August 07 and paid it without demur, to use a phrase from the defendants in those proceedings, it would support the defendant's defence that the first claimant was aware all along that the products were risky. I'm going to make good that, my lord, by reference to the pleadings and then the documents in the case. First of all, the pleadings, the Lordship will just pick up, we'll start at bundle, we've got bundle 4 in hand, I hope.
Yeah.
Going back to the first tab, divided 57. I'm not going to go through the claims, but I really summarised them. I'm just going to show you how the claim, the 10 million featured in almost a neutral narrative fashion of paragraph 45. You'll also, I think, have seen this already, at page 1658. That was unrelated. At that time, the claimants thought that was unrelated and was just paying in for a loan in support of another loan application. Then, it was also important, I think, to see the plea about the risky products, because this was relevant to their defence. If you go forward, the only other paragraph I want to take the Lordship to is paragraph 78, which is on page 1666. If your Lordship would read that to yourself, it's the defence that, it's the claim that the products sold were aggressively high risk and were unsuitable, including the leverage product structure put into place.
Yes, I read that.
Then I'd like your Lordship then to pick up the amended defence, which is in bundle 2. Keep bundle 4, if you would, nearby. In bundle 2. Divided 44. We pick up the first statement about the risk, the claimant being aware of the risk of margin call as a matter of course, the essential feature of the claimant defence, paragraph 61 to 2. And the wording is quite important in this case. If you read, it's page 997.
Yeah.
They deny that they were told major misrepresentation. They would deny the representations that they said they would never lose their money in negligible risk. Rather, Mr. Wiley and Mr. Blond, I think we call him, explained that 100% capital. The Lordship reads that, particularly the last two sentences. Concept of leveraging portfolio first phrase and was his own strategy. And at 62, importantly, the Lordship will go ahead and read that.
Yeah.
And the Lordship reads that it was raised by them, and they were aware of the risks. It was their strategy. In fact, they said Mr. Wiley said what they were trying to do was not prudent. Then at 70, the actual, this is the 2010 pleading, at actual, page 70, which I don't think the Lordship has seen, they didn't in fact, all they said about the 10 million, that's the first sentence does not omit paragraph 45, that's the claim about the 10 million we paid for loan application. Yeah. It doesn't raise here about a margin call or anything, it's just said that wasn't admitted. Where it comes later, in respect to a different pleading in the points of claim, and it's at paragraph 9, just before we get there, at paragraph 78, you'll see a specific averment that the first claimant was aware of the risk of leveraging and margin calls. Well known to the tile. That's in paragraph 78, particularly the last 3 sentences.
Yeah.
And then going on to 94, and it's the Lordship has seen this paragraph, and it's important the wording here, because this is where this 15th of August conversation comes in. Before further statements produced, does your Lordship have it?
Yes.
Position of the council was brought to the attention of Mr. Hahn and telephone call on 15th of Mr. Block. We now know that to be false. Due to the claimant's leveraging strategy, this is their defence. As at the 15th of August, a collateral shortfall existed. On a value date, the 31st of August, the sum of 10 million was received on their account, and that's what they say there. That's their pleading. Of course, this was their pleading only, and it was some time before, 2 years or so before we got any documents in support of this, and further on there's matters about putting into the witness statements. But that's what their defence is fairly, then it's all about the risk. It's all to do with us. That's why this conversation is relevant. And also, your Lordship will go to paragraph 117, and I think reads to yourself, which is about where we plead. It's their response to our plea about the risky structure. And the Lordship reads in particular over the page D, E, F, and G. And just give you some further references, 179.2, they make a denial that the products were unduly risky or aggressive. And in 201, and this is important, they deny there was any causation they suffered any of the losses, or the first event caused such losses, whether alleged breaches are otherwise, and this consequences as well expand on. Now, that's D2's re-amended defence, which was served in April 2012, that is after the exhaustion of their jurisdiction challenges. That may be found at the bundle 4 divided 59. And again, the emphasis is on being aware of risks. Lordship picks it first up at 36, where they say that the term sheet signed informs the paragraph 36 on page 1750.
Yeah.
And it's the alert about risk. That they were aware of risk from these term sheets. In fact, they would have been aware of risk. Going forward to 51, and another reverment about being warned that matters may go up or down. Going forward,
that's not part of the amendment.
No.
Okay.
Going forward to 65.
Yeah.
Now, in April 2012, they respond to our paragraph 45, the neutral claimants paragraph, with their claim that it's specifically linked, in fact, to shortfall. The Lordship sees that from 65A, B, and particularly B, it was transferred to cover a margin short.
Should that be in red?
I don't have any colours on this. The Lordship might be
I
able
don't
to
mean red, but that is an amendment, isn't it?
No, it's the original one.
It's the same as before, is it? I thought it before.
I think from
I thought as to paragraph 45, there was a different plea.
there is. No, in this, I believe, this paragraph 65 pleads as from the 29th of February 2012. I think that's correct.
It's part of the original.
Yeah, exactly. 29th of February 2012. It's later. The only amendment to this pleading is in the following year, which is in response to the new rate.
Anyway, well, I don't assume I've got a grasp of how the amendments went, but up to now, I thought the earlier version of the defence said something quite different in response to paragraph 45, but I obviously may be wrong about that.
I think that's not.
That was the first one.
That was the first defendant's defence.
Yeah. Oh, that was the first
defendant. This is the second defendant's defence.
Understood.
Okay. And then at 84, but he does adopt the second defendant's defence as regards the claimant's leveraging strategy causing the shortfall. Your Lordship can see that if your Lordship goes forward to paragraph 85, which is almost an exact replica of the first defendant's defence. And you'll see there again, second line, due to the claimant's leveraging strategy, as that fittings orders a collateral shortfall existed, a sum was received in the first claimant's account. So, and then at 108, if your Lordship goes forward, and again, this is their pleading to the same paragraph 78 where we claimed risky products, and if your Lordship looks reads that to himself, and particularly at G, H, and I, the leveraging investment products claimant's own strategy is to infer that experienced investors were aware of the risks of leveraging, and then the event the claim has not been financially advised. So that it's really G, really, there. And then at 154, going forward, you'll see at 154 and 155, specifically at 154 in the second sentence, the claims for experienced investors and aware of the risks associated with their investment strategy, including the leveraging, and they were about all the risks. 155. So this is a key part of their defence, and you can see this in Walier's witness statement in April 2013, where he gives the evidence to support these pleas. And my Lord will pick up bundle 3. At 56. Paid paragraph 3, divided 56. Paragraph 121. Sorry, beginning paragraph 119, because there's a question about a meeting on the 22nd of June 2007 and whether our clients were told they wouldn't have any risk and the risk of their investments was negligible. And Walier disputes that, and in particular, you'll see how he makes it very clear that the leveraging strategy was his own strategy. It's paragraph 120 at the end of that. The concept of further leveraging the portfolio was first raised with Mr. Khorafi and was his own strategy. And we're discussing the risks.
Yeah.
The risk of margin calls and so forth. And then, of course, at 163 of this witness statement, we then have the significance of the conversation to the defendants, beginning due to Mr. Khorafi's leveraging strategies on page 1420. And if you read 164 to yourself, you'll see the reference there to asking him, explain the position, asking for the money, and Mr. Khorafi did not express any surprise or confusion. I told him that a margin will be made in the account, additional funds are required. These are the few formulated, the 10 million was received. And this is backed up their claims. Our claim was aware of the margin call risk as he paid up without to know. This is, Lordship gets more of this from the defendant's opening submissions. Which your Lordship won't have in the bundle, but we have managed to dig up. These is the opening submissions of the defendant for trial. And I could you procedure to do it, but I missed. Thank you.
Where do you want to put this?
First.
I would suggest my energy will come up with a bundle reference. You think about it?
Well, come up with a suggestion, of course. When it says opening submissions, well, these are pre-trial.
These are pre-trial.
Yeah.
First.
Of the first defendant. Yeah. And your Lordship, I just want your Lordship to go through this, and you'll see the issue of risk and not his knowledge as a result of this conversation, importance to that and how it features. And your Lordship will get that from paragraph 4 in first. About the claimant choosing to fund the entirety of this by way of borrowing. That is about their responsibility for the risky strategy is central. And that the suitability of the notes, whether they were suitable or not. The second paragraph of 5, the second paragraph, the structure of the notes based on the claimant's requirements. Paragraph 5, the structure of the notes based on their requirements. They wanted risk, and therefore that's what they got. 11.1, and this is where we talk about causation. 11.2, even if in any event the person has acted in breach of duty, such breach has not caused the claimant any loss in that, A, even if differently advised, the claimants would still have bought the same or similar notes on the same leverage basis. And the point being that if they were able to show that they wanted this risk, it wouldn't have mattered. They would have got these products from someone else. Whereas, as you also recall, the judge found that we were not trying to buy a risky product, and that we wouldn't have bought these products elsewhere, and that is the nil transaction basis. So when the judge found on that basis, he found against the claimants on this point. Just going forward, 68.4 to 5.
Give me a page.
Paragraph 68.4. This is about the claimants must have understood about the risk from the notes product, and they, if any, were capable of looking after their own position, 68.4 and 5. And then at 75, and this is important, this is how it comes into causation. In any event, even if, contrary to the first defendant's defence, the claimants are able to establish liability under any of their course of action, the case must fail as the claimants have suffered no losses caused by the material breach. Even if, which is denied, particular, the Lordship will see it has been inferred the claimants in any event fully understood how the notes worked. They were sophisticated, clear from the term sheet, they were sophisticated to see, and then the Lordship goes across the page and reads that paragraph to yourself. It follows this to be inferred. The first documentary evidence shows the first claimant fully understood by August 2007 how the products worked, even if he had not previously understood, i.e. that they had to pay margin, yet the claimants remained invested in the product and they made a new investment. It follows to be inferred that even if they had been differently informed or advised, they would still have bought the same notes on the same terms, whether or not arranged. And that's, I want to take Lordship just to see the way.
I mean, the 10 million there is the same 10 million.
Yeah.
August 2007 is the time of the conversations.
Exactly.
No, that's not the same thing. It's the third claimant's thing.
Sorry, the 10 million, or the August 10 million, is within that 40 million which cat note.
Right, but it's not the same 10 million.
It is.
Yeah, I thought so.
It is exactly that.
It's not the 10 million.
It goes into the which cat note. It does. That's a matter of fact. So that's how.
But there was a balance of 30 million on the which hat note.
Exactly, which
Yeah.
was.
Yeah.
So then that's how it's applied to the first one. Second defendant, similarly, same defence of risk in the skeleton. My Lord, you'll find this one actually is in the bundle. Bundle 4, divided 61.
Yeah.
And it's only two brief passages. Page the very back, 1911. This is the passage which John Chadwick disagreed with, where the bank tried to blame Khorafi for the loss of my client, for the losses. Beginning of the passage, this is yet another case arising out of the global financial case where investors seek to recover their bankers the losses they've suffered. Lordship briefs are 51 and 52. Particularly 52, borrowed with full knowledge of all the risks central to them. And this is why they, in this skeleton, actually states that the 15th of August 07 conversation is extremely significant. I ask your Lordship to see this, going back in the skeleton to page 1886. Beginning, yes. This was the claim made by us, 31st of August, i.e. the paragraph 45. We say Mr. Khorafi transferred 10 million from his own funds to the Lordship's sister loan application, the funds we used to invest. And then, this is their commentary. This is an extremely significant misrepresentation of the position. The 10 million was filed as a margin.
I understand that there, actually.
Okay. What they do, you can see this if you go back to... they set out the claimant's claims, factual claims, in the heading. Their comments on it are in italics.
Yes, I'm with you.
So they themselves saw this matter. It's extremely significant, and not something not of significance, as my learned friends take a view. Now, briefly, because my learned friend said that you could see from our skeleton that we were well aware of the dishonesty from this date, the complete dishonesty, I just want to go off to see the claimant skeleton, which is first of all in divider 4. Sorry, same bundle, bundle 4, divider 60. And at 72, but at 72, I'm just picking that up because there's a reference to the parties disagree over the risk of leveraging the discussed at the meeting. But more importantly, going forward, at paragraphs 100 to 105, this is the passage my learned friend relies on. And it says, this is our skeleton, by August, it appears that there was already a collateral shortfall, and that's the, it appears that we were uncertain for a reason I'm going to come to. And he refers there to the documents my learned friend's taken you to, and questions and asked. 102, he just sets out the evidence about the meeting, which eventually was found in my client's favour. And the claimants, this was 103, according to the request, the claimant paid in 10 million. The claimants claimed this is the payment of margin. There's no contemporaneous evidence to demonstrate they were informed that the account was already in margin call. And then you'll see further later, then sets out the internal email from Mr. Blond. But at 105, very shortly after, it appears they granted further facility of 30 million, increasing that to be invested along with the 10 million transferred. And as your Lordship will see, this led to some confusion on our part as to whether it really was margin call. Why would you be putting in money to cover a shortfall if it was then actually treated as an investment of yours internally by the bank? Hence, the not totally certain of the complete fraud. Your Lordship will see this in Mr. Hill's oral submissions, going ahead in the same bundle to page 2063 behind divider 63.
To
63.
yeah.
Your Lordship, I think, has seen this passage.
Oh, yeah.
And he says, I mentioned earlier these investments were so risky they'd like to go into margin call and short order, and that's what happened. They're in margin call by August of next month. Very oddly, the margin call was in fact misrepresented. The oddity, you see this as an oddity, but to them, not central. What was put to him was that he was being asked to invest a further 10 million rather than in fact paying 10 million as a margin call. What's particularly odd about it is that the investment of that 10 million was in fact accompanied by a further 30 million in the initial purchase, 40 million called a witch hat. So that was, in any view, a very bizarre way to treat a margin call if it really was a margin payment. And it was only, of course, when the judge found out, it made his findings that it was a margin payment, that it was.
Does the judge deal with the witch hat note?
He does ask questions about the witch hat note. Right. And I think in his judgment he makes findings as to what actually happened as matters of fact. He made a comprehensive judgment of matters of fact. Now, turning to the cross-examination of the claim, contrary to the impression given to your Lordship by my learned friend in his skeleton footnote 75, there was a coarse cross-examination by the defendants of the first claimant about the dishonest statement. The Lordship will pick this up in bundle 5 because it's so central to that one about risk, being aware of risk. From bundle 64, at page 2251, starting at, and he's cross-examining Mr. Khorafi about his paragraphs 87 to 90, which deal with the 15th of August conversation. At the beginning, he's asked about what he says in his own witness statement, that's paragraph 87. You were well aware that the value of your valuable investment portfolio had fallen, I put it to you.
Where are you reading?
Sorry, I'm at line 17, Q. The next point is, I suggest to you, you were well aware at this time in order to go to the value investments had fallen. He says, I didn't. And he said, Mr. Wally, and I will take you to his statement in a moment, says he met you in London. He then picks up Walier's witness statement and says, did you have this meeting? And he says, I don't think so. I'm not confused about the exact meetings. It wasn't a meeting. And then he goes back to your witness statement, line 23 on page 2252. In your witness statement, if you go to paragraph 88, which is the next one for I've reached, if you keep Walier's next to it so you can look at it, you don't, I think, refer to a meeting at all. And then there's, if your lordship reads 2253, to 2225 at line 12, you'll see there that he goes over his evidence, but he doesn't formally put to him that it's wrong, because he gets lost in Arabic translations, and instead he just stops. And so I think that's why Mr. Justice Chapman said you weren't actually challenged on it, but instead he goes back at 2255, line 7.
Sorry,
Sorry.
a bit too fast for me.
If your lordship reads...
I'm reading 2254 at the moment.
Great, I'll leave it.
I've now got 2255.
And then he puts to him Walier's evidence, I take it, the lordship to about it, and that's what happens over several pages, 2255, 2256, and 2257. The lordship just reads that to yourself.
Okay.
D2, of course, had the opportunity to ask questions that left the factual cross-examination, as I understand it, to D1. And were represented by the same solicitors, I remind.
Okay.
And so it was put to him, therefore, on the basis of what Wiley had said, that he was told and knew the 10 million was for margin call, he paid it without a real, and therefore it supported the defendant's case. Now, it was even accepted by my friend solicitor, Mr. Abbott, in this application. There was detailed cross-examination of the first claimant on this. I won't take lordship to the references. Mr. Abbott's witness statement, paragraph 41B, bundle 1, 17138. So the defendant Sarasin claimed that they chose, in the skeleton now, that they chose not to challenge paragraphs 80, 80, 90 because not a claim is just, it's like fancy. First of all, it's not correct. It doesn't sit easily with the transcript of what we've seen. He does cover 88 to 90. He then challenged it by reference to Wiley 164. And of course, we've got no evidence from Mr. Brindle about that, what the decision making was or wasn't. Mr. Wiley, without prolonging this much further, he was cross-examined on the basis that claimants were not told of the margin call by my client, and no margin call was in fact made, and the references to that are bundle 6, divider 68, 2968 to 75.
Yeah.
And in particular, he's asked, we might just pick it up at bundle 6. So it's divided 68. Starts at 2968. it goes through to page 275. I'd like your Lordship to take time just to read it. And I'll ask you to stop at 2971, line 12. Just stopping on 2970, so at 6 to 10, that's the passage that was, as it were, a light bulb moment in terms of the authority, the actual authority of Mr. Wiley to make margin calls on behalf of the bank. Then going forward.
I got to 2971.
Right, at line 5. Well, just going on a little bit after you've read to 12. You then at 2971 onward to 2973, you get the questioning about whether it really was a margin call if it went into the witch's hat. Hence the confusion.
I'm on 2975.
Once that section is finished, that would be fine. Completing the picture by before the judge, the defendant's, the first defendant's closing submissions, they're in the bundle, and they are at, and they both place it in the context of the defendant's issues I've set out. Bundle, first of all, 8. Divider 73. Yeah. Page 3793. Beginning at paragraph 36.
So
3793.
Yeah.
And it's the heading contractual and non-contractual claims.
Yeah.
This comprises the rest of the case. It is the last sentence is it's proposed to state the essential findings of fact, which the first defendant invites the courts to make. Essential, not insignificant, not minor, but essential. And then it goes forward to 40.
So where are you reading on 3793?
Sorry, paragraph 36.
Yeah.
First paragraph. And then one of the essential findings of fact is this conversation in there to be found in their favour. You get that from paragraph 40. The second tranche of property was purchased 100% by funds advanced by the second defendant. The Lordship reads himself. The idea for the leveraging came from the first claim, Mr. Time, not from the first claim. Indeed, from this time onwards, they were determined not to use as much leverage as possible. So 40 sets out how they fully understood the risks, as the Lordship has seen on the pleadings. And at 41, they then address the two collateral shortfalls in the alleged margin calls. And in the second sentence of 41, they were in fact paid without protest. This indicates, third sentence, that the first claimant fully understood how leveraging would create the risk of margin calls, but he would have to be prepared to pay. He attempts to explain it away by some bizarre explanation, but he was caught out and refers himself. Of course, it was a margin call, as he well understood, and that was, of course, entirely false. But that is acceptable part to their defence. The Lordship sees, I won't say the Lordship sees it again in the oral statement of Mr. Brindle and the bundle divider 8 forward, going forward, divide. In this bundle, divider 71, page 3646. In fact, right here, we must see it. 3646. Uh, 3646, beginning at line 4. My learned friend looked at what he called our factual section, rather danced over paragraph 40. Does the Lordship see that?
I'm so sorry, I was reading further on in that. So the divider 71, 3646.
Divider 71, 3646.
Yeah. And then
Line 4. My learned friend is looking at what he called our factual sanctions, rather danced over paragraph 40. So we'll see that. That's the paragraph I've just taken the Lordship's chair in their submissions. And if you go on and read to yourself from 10 to 16, you'll see the expression. The fact is, he did receive 2 multiples, which he paid without demur. They were deliberately adopting high leverage strategy. It's central to their main defence. Defendants, the bank's closing submissions we've dug up and are at. I'm going to hand up on this, I'm afraid, slightly in that way. I thought there was. There's no one here, so I'm just going to hand up to them. Thank you very much. And they cover it at the back, the question about risk of their skeleton in the issue of risk is covered, paragraph 57, little bracket 8. Sorry, little 57 on page, paragraph 57, little bracket 7. Equally, once on proper analysis, it's towards the back of the skeleton. The Lordship reads that he must have known the risk of investments, and then about the risk of margin calls at 8, they must have known about those risks. And then at 59 to 63, they deny causation, including that they deny the nil transaction basis. The Lordship sees that at 63. If that is correct, the nil transaction basis is not applicable. And they also deny causation earlier in respect of the regulatory claim at paragraphs 24 to 26. So it's on their case as well, but of course they were piggybacking on the first defendant in any event. So that, your Lordship sees, that's what the judge was faced with, was that it was. So what happened in the conversation 15th of August features an essential step in overall defences with both defendants, namely being integral to their key claim that C1 was well aware of the risks of the leverage product. That defence was dismissed by the judge. The Lordship could see him dismissing that judge, not just about the conversation, but about the question about risk. We'll pick it up in bundle 8. First of all, he dismisses the claim that they were well aware that they had proposed the leveraging strategy, yes. But the claim that the claimants proposed the leveraging strategy,
where are you?
It's a paragraph 197, it's divider 75, paragraph 197 to 8. And you'll see that it's a conversation about what it begins, I'm so sorry, 3946.
Okay.
And he sets out there at 192 what Mr. Khorafi's evidence was, what happened in that meeting. And he said that there wouldn't be any risk, there wouldn't be any problems with it. And he sets out Mr. Walia's evidence that I've taken your Lordship to already over on page 3948 and 3949. He sets out Mr. Wiley's evidence that it was Mr. Khorafi's leveraging strategy. I take your lordship to that passage. He sets it up. He then discusses what Mr. Wiley says in his cross-examination at 198 about the strategy was all Mr. Khorafi's idea. He knew about all the risk and so forth, and knew about the risk of larger balls. And he rejects it. He rejects Mr. Wiley's evidence. He accepts the evidence of Khorafi, and he doesn't accept Mr. Wiley's evidence. He rejects that issue. He then, going forward at 207 to 12, as I think in passages your lordship would have read, if not seen, is his findings of effective dishonesty against Mr. Wiley about the conversation. If your lordship hasn't read it before, just your lordship reads yourself 207 to 212.
Yes, well,
I think
sorry,
your lordship
300 or 200.
No, 212.
Yeah, no, I have read that.
I think he then goes on to reject the contention the leverage products was suitable because of the claimant's appetite for risk. Yeah. You'll see this at 295. I turn therefore to the question whether the advice, look at the heading, whether the advice recommendation transaction was or was suitable having regard to the claimant's investment projects or risk tolerance or other requirements of factors which Sarasin was or reasonably aware. And he turns then to that question about whether they were suitable, whether it was about risk. And he goes, at 296 he finds, he records the claimant's arguments that in particular at 2962 that the leverage investments were unsuitable and that they were very risky and the risk of margin calls. And at 297 he records Sarasin Alpha's defence that the notes were plainly suitable having regard to claimant's investment objectives and risk tolerance and any other requirements of which they were aware. And at 299, 300 and 301 he roundly finds in favour of the claimants on this issue. Yeah.
Yeah.
And in particular 301 and 300. So, and then he therefore makes his findings at 303 that Sarasin Alpha fails to comply with his obligations and so forth. So central to conclusions about risk, and he also rejected the claimant's causation argument at 309. Is it paragraph 309, 315? And you'll see there at 309, he sets out Sarasin's defence that they were well aware of the risk, and that therefore at 310, even if they had been differently informed, they were still able to the same notes and the same terms. And he, as I described earlier to Lordship, you go forward, he rejects this, and he says that 359 subsequent that was caused by this behaviour. Okay. And he also finds at 400 that in relation to the second defendant, that there was, and the question about whether the second defendant would have to pay, would or should have to pay compensation for the breach of the regulatory requirement, the prohibition, financial prohibition, he's satisfied in having seen the evidence that they can get it on causation, effectively the same reasons, and we go at page 4035. The claimant claimed to be bottom of paragraph 400, the claimant claimed to put back in position they would have been if they had not purchased the investment. It is said to be clear from the evidence that there was sufficient causal link between the original loan monies advanced, the investment purchase, the leveraging provided, the losses suffered, and they were closed out. The bid was to get an order, and although the bank rejected, he agreed. So he's rejected the arguments also of the bank on causation. So the defendant's loss on causation was the bank, as judge found against them. Essential steps in his reasoning against their defences. If he'd found the other way on the 15th of August compensation, of course, then he'd have found an awareness of risk on the claimant's, on the first claimant's part, which have unravelled all these claims and this part of his judgment. So this leads to my submission, my Lord. But faced with all of this, it does seem very difficult for my learned friend to sustain his submissions that no issue estoppel will or can possibly arise in these proceedings concerning the dishonest statement, or somehow this is unfair that it should. On the contrary, we say it is patently fair in these circumstances for the first claimant to deceitfully rely on these findings, especially when the judge's findings were so damning about Mr. Wiley's dishonesty towards the first claimant, which findings have thus given us, we say, a strong foundation for a claim in fraud against the bank by the claimant in these proceedings. And I've taken your lordship to the findings. You've seen them. I don't need to remind your lordship about them. But it's important also, so we have the findings of fraud. We also have the findings of agency, which your lordship put very well in the Court of Appeal at reference, we've seen, I wrote it to 10-101-5025. So they were found agent for the acts in the course of their relationship. And of course we had, crucially at the trial, we say, Mr. Wiley's admission that he had authority actually to make margin calls. It was a normal practice for CRM to do so, and that was not something that we had covered or alleged because it hadn't been part of our awareness. And that reference I take the lordship to 6682970. So, given these findings, we say, of the second defendant's dishonesty by the judge, and Wiley's effective admission of agency and the Court's of Appeals findings of agency, it's unsurprising that we should bring these new fraud claims against the second defendant based on such findings, seeking compensation to cover for losses caused by such conduct, insofar as we've been unable to recover them by the 2009 proceedings. Now, I just want to take you through the new claims briefly. They may be found in the point of victims of claim. I'll also have taken you through them. So I want to make 3 overall points. It's bundle 1. At 5. As I've said, first point, they have a different factual building blocks to the old claims as regards liability issues. They're not concerned with the mis-selling of products, D2's products in June and July to the claimants, and all those myriad of regulatory, contractual misrepresentation, negligence issues surrounding liability for that mis-selling. If your lordship goes to 65 to 75 in the pleading, they centre fairly and squarely on the dishonest statement made on the 15th of August and the claimant's liability. That statement, I know your lordship has seen that, but and this then flows into the formulation of the 3 types of legal claims themselves, and these are at paragraphs 118 onwards, 118 to 141. The first is what I'm going to call the bare deceit claims arising out of the statement, and that's paragraphs 118 to 123. The second type of claims are the negligence claims. They are the breach of advisory duty in relation to the margin call, and these are simple negligence claims under DIF law, English law, or Kuwaiti law. The second defendant liable for the statements of Wiley. And those are at paragraphs 120. First, the breach of advisory duty, as set out in 125. And those are the breach is set out at 127 to 128. And those are the breach of his duty, he failed to provide correct advice. And there is also a negligence claim going over the page in terms of breach of information, failure to give proper information, and that begins at paragraph 133, and you'll see the breach of duty there of negligence duties 135 to 136. There are a third type of claims, which is the dishonest false representation claims made in the context of that duty of care. And those are the heading, the claims at paragraph 129 to 132 in respect of the advisory duty, and 137 to 140 in respect of the information duty. Now, They are all based on the August statement and the legal consequences flowing from that. Although my learned friends have said that they are new claims. They have quite a different, that's the first point, different building blocks. The new claims also have quite a different, a radically different, like quote Sir Richard Field, factual focus as regards to the loss issues. My learned friends didn't quite show you, but Sir Richard Field did look at the type of quantum claims that the property losses involved, and in his case, a small part. And that was the phrase he used. So I'll just show you, Lordship. Paragraph 10, volume 10. Divider 99. This is when he's dealing with my client's appeal against Mr. John Chadwick's refusal to let in those loss claims into the 2009 proceedings. And at 33, he states there, in my judgment, page 4813, paragraph 33, in my judgment, it can be readily concluded that the claims construction are to be bound to fair. The RAFCO losses are radically different from losses arising out of the ABP lending, because of course the ABP lending was rather narrow type of losses being sought arising out of the loans in respect of the purchase of the defendant's products, and these are much further afield into terms of property losses. Now, but I don't really need to go into details to show this. The Lordship will be well aware that the two different types of claims, and those claims were of course not investigated. Now, so that's different factor flows as regards loss issues. But thirdly, although both the liability and loss issues have different focus, we say the 2013 trial has nevertheless dramatically narrowed the scope of the liability work in these proceedings, as the points of claim show. Thus, as I've shown your Lordship seen, the deceit claims are based squarely on the judge's findings on the August 07 statement and form a clear issue of stock, what we say between the parties. I'll come on to my own friend's point in a minute. In light of this, and the judge's findings on general agency of Walia, the second defendant, while there's specific omissions in respect of this habitual margin calling for the bank, it's impossible to say, we say, see how the bank has any real defence on liability to this claim of fraud. Obviously, the extent of the losses are more arguable, and that will be explored at trial, but the fraud claim appears to be a very good prospect indeed in liability terms. Now, my learned friend today, as I say for the first time, said, well, we'll challenge the issue of stopples because we think we can challenge them as not being issue of stopples, and if they are, that they're unfair. As to the first point, whether they're issue of stopples or not, we think, as from what I've shown to the Lordship, that we have shown and will show quite easily on an issue before a judge, it would be a half-day issue of that, that they are not issue, that they are, I'm so sorry, I correct myself, that they are issue of stopples in light of the submission I made to the Lordship so far. That shouldn't, we suspect, trouble the judge too much. And as to the question about whether it was unfair, okay, well, they're unfair, but we might overturn them on the basis it would be unfair. Now, the Lordship will know that there are circumstances, and the House of Lords have found this in the Virgin Airways and Zodiac case, that you can go and look at those issues of stopples if things, if they were obtained in an unfair way. You might have done something different. The Lordship put more different things would you have wanted. But there's nothing really, if you look at it, unfair about what happened. It was a central issue to the defendant's case. They litigated it with such resources as they chose, and the judge made a square finding right against them. And so we say that unfairness won't arise in this case. So we think it's unlikely to succeed, and certainly not unfair in Henderson and Henderson terms. I learned Fred made that submission earlier. It's not unfair in Henderson terms anyway, and of course we'll come on to this, but we weren't conscious of holding back claims. My client's evidence is he didn't appreciate the claims until he heard the evidence of Mr. Walia in court, so he didn't appreciate he had a claim. So this is an unconscious breach of the ALDI guidelines, not a conscious one, and that would be important. Furthermore, the 2013 trial judgment also materially assists the negligence claims, as they are also based on the dishonest statement and the converse failure to tell us at that time of the margin call. The assumed duty of care issue has also been assisted by the judge's findings that the first defendant and the second defendant both owed contractual duties of care to the claimant in respect to the selling of their products under DFGAD or Swiss law, which would obviously assist the trial judge in these proceedings in assessing whether there was also a non-contractual duty of care. In the judgment, in the references in the judgment, I won't go to paragraph 333 and 407. 407 and 411 to 413. And of course we have the findings about the agency of Wiley and his evidence. So that would also help, and similarly, such findings would assist the fraudulent misrepresentation claims arising out of the duty of care. So, in those respects, the work has narrowed, but also the judge, we say, the trial judge has materially reduced the causation, remoteness, and quantum work. If you look, it also looks at the points of claim again at paragraphs 51 to 64 in the bundle 1. That divide of 5, paragraph 51 to 64. Headed in the liability judgment, the court has made a number of factual findings which will effectively assist by way of res judicata. In particular, '59. That they wanted no risk. In particular, 64, had they been aware of risk, they would not have purchased the notes. And accordingly, their reaction to the truth about the concealed margin call is likely to have been very negative indeed and led to the chain of events that we plead in paragraphs 143. And of course, in 110, to 117 of the pleading, we plead the judge's findings about the bank's knowledge of our property dealings at the time, which will obviously assist in this respect in terms of remoteness and the negligence claims. That's 110 to 117. So, I'll just give you a lordship of those references. So in summary, we have strong, new, different claims of fraud and breach of duty against the bank. No defence served, no res judicata issues against my client, but plenty in favour, no limitation issues, and much work done by the 2013 trial judge already in respect of such claims. There really must be, we submit, be an exceptionally good reason not to let the claimant, my client, pursue these serious claims. And what we say is that the second defendant's reliance on the rule of Henderson and Henderson is not good enough to do that in these circumstances. And that then brings me to the law, if I may turn to that. Now, my learned friend has already taken the lordship to much of the relevant law, and the lordship will also be familiar with much of it already, so I'll confine myself as far as possible to the parts that we want to emphasise. Looking first at Johnson, Gore, Wood and the claimant's authorities Act 11. Modern day authority on this reasons we'll come on to. Now, only 2 judges considered the abuse issue in any detail, Lord Bingham and Lord Millett, and both of them, in approaching the subject, emphasised the point that I just made, that there must be a very good reason to deny a party a right to bring an arguable claim. Hence, the use of strong terms there must be abusive or oppressive conduct or manifestly unfair. We also pick this up with Bingham's judgment at 22 C to D, the rule of law.
So where are you?
I'm on page 22, C to D.
Okay.
This is Lord Bingham's judgment. The rule of law depends on the existence and availability of courts.
Yeah.
Litigants are not without scrupulous examination of all circumstances to be denied the right to bring a genuine subject of litigation before the court. And his citation at 24A to B of the Privy Council in Brisbane City Council. This is the true basis of the document. It not only to be applied on the facts of such matters of abuse, otherwise there's a danger of a party being shut out and bring forward a genuine subject. Going forward, you'll see this in Lord Millett's judgment, page 59, in D to H. It is one thing to refuse to allow parties to relate this question which has already been decided. It is quite another to deny the opportunity to litigate for the first time a question which has not previously been adjudicated on. The latter, although not the former, is prima facie a denial of the citizen's right of access to the court conferred by the common law and guaranteed by Article 6 of the Convention on the Protection of Human Rights. Stressing the importance of that. Now, while we're on that passage, the first question is going forward at H. Going down the, sorry, not before we get to H. If we go to Lord, his quotation of Lord Wilberforce, it will only further down at F, it will only be applied in the facts of such amounts of abuse.
Sorry, where are you?
I'm at F.
So page?
I'm still on 59.
Yeah.
He sets out the Brisbane City Council quote like in your lordship. There is therefore only one question to be considered in the present case, whether it was a precedent of abuses, otherwise an abuse of the court to bring his own proceedings against the claim, and he could have brought them in as part at the same time. The question must be determined at the same time when Mr. Johnson as the same time brought the present proceedings and the light of everything he could have then known. This sense that there is no doubt, of course, that Mr. Johnson could have brought his action. It does not follow that he should have done so, or that his failure to do so renders the present action oppressive or abuse the presence of the court. Then I want to go to Lord Bingham's judgment. The Lordship has already seen this in some detail at 31. The passages I particularly want to emphasise is the overall test at D to E. That is to adopt too dogmatic an approach to what should and might have been a broad merits-based judgment. You also see that.
Yeah.
Which takes account all the public and private interests involved, and focusing on attention on the crucial question of whether, in all the circumstances, the parties were misusing or abusing the process of the court by seeking to embrace an issue which has been raised before. And that's the question that all the authorities centre on after your Lordship consideration going forward. So they must, well, and as he said, it maybe could, but the question is whether it should. And so, my Lord, they must satisfy that we could have raised it before the first hurdle, before we get to the question of should or unjust harassment and overall abuse. And indeed, at C to D in particular, he says that there will rarely, going up a bit, there will rarely be a finding of abuse unless the latter proceeding involves what the court regards as unjust harassment. So that will should using a lot of the authorities. Strong words, not just could and should, but something more. Now, an additional element the Lord, my learned friend, took you to in this passage was about a collateral attack. Now, and it could make it worse. My learned friend says what we are doing is a collateral attack in substance, it is said. And what we'll say on that point, and come to it later, is that it requires a decision. A collateral attack requires the judge in these proceedings to come to a decision which must mean the earlier decision was wrong. That's the point. That's the authority that is Ridgewood Properties. I'll give you the reference. Arnold, Mr. Justice Arnold in 2014. It's a classic exposition of that. It must mean that the earlier decision is wrong Here it is not a collateral attack on quantum decisions in 2015, which were based on construction of Mr. Justice Chadwick's order that our property losses could not be brought in. So the first question was a matter of construction, decided by Mr. Justice Chadwick. The first decision, a decision in these proceedings by our Lordship to let these proceedings in would not require a finding that Mr. John Chadwick's decision in 2015 was wrong. We accept we cannot bring these proceedings, bring these claims in the old proceedings, and we're not trying to get into them. They're different. With my learned friend saying it's all a matter of substance, wouldn't be right in law to say that. And indeed, in terms of what Mr. Lord Bingham meant himself by the words collateral attack, he meant exactly that. And you can see that in going back in the judgment a little bit at 24H to 25C. If your Lordship reads, he's addressing a case called House of Spring Gardens. Yeah. And your Lordship reads to yourself to from H at 24 through to C at 25, you'll see that that's exactly what he meant was a collateral attack when he was then using it in the passage in paragraph 31, page 31.
Okay.
Going forward, page 27, he addresses a case called Barrow and Bankside, and I want to take your Lordship to that authority now. And that was when it was found to be not an abuse to sue the same person again in Lloyd's litigation under another head, having previously sued them, because in that case, in the Lloyd's litigation, there were, as we all know, there were great group case management rules in place, so they couldn't have been brought anyway. And although the facts are specific to Lloyd's, the principle applies importantly here. And I ask the Lordship to pick up our bundle of authorities. At 5. Barrow and Backside. Does your Lordship have that? In the head note, the Lordship will read that, but I particularly want to highlight the sentence. In 1993, the plaintiff, the name at Lloyd's, and a member of the actuary began an action together with over 3,000 claims against 71 defendants for breach of contract and negligence in the conduct of underwriting business. The judge concluded the issue in favour of the plaintiffs. The plaintiff immediately began a fresh action against 2 defendants, the first of whom had been a defendant to the group action, claiming damages in respect to a different generic class of claim, namely for breach of duty in respect to his portfolio selection. And the defendants object on the Henderson principles. Held, dismissing the appeal, that the rule which required parties to litigation advance the whole case of one time defendant from returning to court to advance matters might have been raised, did not apply to a claim which could not have been dealt with on the first occasion. That given the procedural management of the Lloyd's litigation, the terms on which the group action had been, the plaintiff's fresh claim could not have been dealt with in the previous litigation. Commenced the fresh action did not subject the first defendant to an unnecessary series of trials or prejudice it, and therefore the procedure adopted by the defendant was not an abuse of process. And we see that that's a good explanation for what happened, and we can go forward to 69, page C to D. The question on these novel facts, how should the rule be applied in unusual circumstances? And he explains there at F how it says DT, the normal way it would have been done. It might have been done, but the Lloyd's litigation, why it hasn't been done. and then at G and H.
So what page are you on?
I'm still on 260.
Yes, sir.
You also agrees to yourself, you will be very familiar with this, how the Lloyd's litigation was run in various different ways, and that carries over to 261. So they had this program.
Yeah.
And what effectively, we get to 262B, that brings me to Mr. Barrow, the plaintiff in the present action. He was also good at Walker claims with such ECC, but he only obtained judgment for about 60% of the damages. Up to then, he did no proceedings against for breach of duty. But after the judgment, he did so. They were obviously hoping to make good the shortfall. And Mr. Anthony Mann at H on 71 set forward the argument of why it wasn't an abuse, because the case could not have been decided, because it would never have let his first claim come to trial or be adjudicated upon because of the case management rules. And the judge basically just agreed with him, and you'll see that at 72 at D to E. So it seems to be right to begin by asking whether the procedure adopted by Mr. Barrow is an abuse of the process of the court. I don't think it is. Since his portfolio selection would not have been decided before now anyway, he is not causing there to be two trials when there would have been one. He is not exposing the defendant to an unnecessary series of trials. The defendant is not in truth any worse off as matters stand than if Mr. Barrow had made and pleaded this new claim at the outset. You can imagine the motive to spend. And that's, of course, what we say here. Even if the claim had been pleaded on fraud and with these new losses, and even if the liability had been put in and decided at the earlier trial, we would have had a completely separate quantum trial. And you have what you have now, really, because we've really got decidings on fraud, more or less. There's issues of software, I don't think that goes very far. And we're just having a separate quantum trial to the first quantum trial. There would always have been that. So that's why we say the Barrow backside is relevant to a lordship's decision today. We're not in a materially worse position. The claim was not in a materially worse position, considering what would have happened counterfactually at the hypothetical case management conference had the claims been brought shortly before trial. And of course, it's about, in this case, it's the same defendant. My learned friend said, tries to distinguish the present case and saying, well, it is abusive if it's the same defendant, but actually in Barrow backside it indeed was the same defendant. And indeed, your lordships, in Barrow backside it was also, in that case, pursuing the same losses in respect of a different cause of action. He'd already covered 60%. So we say Barrow backside is helpful. Can I then ask your lordship to turn to Aldi at R bundle 13? Sorry, no, it's a claimant's authorities 13. Sorry, the bank's authorities 13. Looking at the section on Henderson on the law, we pick it up at 756E. The general principles. The principles applicable at the very bottom, 756, beginning at H. Yeah. The principles applicable to basis of reason are set out in the speech of Lord Bingham. It is, and this is important, in my view, generally neither necessary nor helpful to refer to the accretion of authority because it sets out the principles of the court. This is as regards to the principle of the matter. Going at 762E to F, going forward, it's page 203 of the bundle. Yeah. He approached the issue on the basis that the claims could have been brought before, which we don't set in this case, but actually said they could have been brought before. And indeed, in that case, of course, they knew about the claims, whereas the lordship will see the chief court's evidence as we didn't know about this case, that this was an unconscious, not a conscious omission on our part. 764D to H. Yeah. He says at 24, I do not see how the mere fact action may require a trial and hence take up judicial time, which could be said, so can make the action impermissible. And actually, be properly reported is the duty of the state.
I'm so sorry, where are you reading?
Sorry, page 205 of the bundle.
Yeah.
764 of the judgment, D onwards to F.
Yeah.
In particular, the duty of the state to provide the resources, necessary resources, for the arguable claim. And of course, he famously said, we've seen this further on at 765, that the case should have been referred to the court for directions, but in that case, of course, the claimant knew about the claims and hence the need to have done that. I want to then go to Stewart and Goldberg. Which is in the next divider 14. And this is another helpful case. We say this is the same claimants bringing action against the same defendants out of similar facts. Now, Your Lordship, what happened in this case was that the claimant won an earlier action for breach of a solicitor's undertaking, and he then later brought a later action for misrepresentation and breach of contract against the same defendant, which the claim he knew about before, and it involved some of the same facts, and the court found it wasn't in fact an abuse in all the circumstances. And you'll see there that he sets out in the head note that allowing, when the appeal is allowed, the crucial question was whether in all the circumstances the parties was misusing or abusing the process of the court by seeking to wait for an issue. Going forward, the passage I'd like to draw Your Lordship's attention to 826. And the Lordship reads to yourself 826F to 827C. Okay. And your Lordship will see that even more so than here, how the second case arose out of these pretty much exactly the same facts as the first. Yeah. So the two legal claims were although similar facts, the two legal claims were very different. And the first was relatively simple, especially about losses. So this is undertaken enforceable. There was an issue about whether they were given orally or not. Second action, of course, much more complicated, especially about losses. And this is similar on a much bigger scale to here. In the first action, the 2009 proceeded, there were about losses directly arising from the purchase of the products and the bank lending. In this case, it's more complex in terms of the quantum of the losses, about property losses going further. Now, 826D going above, actually, I'll go forward. 839B to D. Mm-hmm. And he said, if we'll read that. So had they tried to bring in the claims which they knew about before the trial, it wouldn't have happened. The trial would have been delayed. Yeah. And at 839F to B, at the bottom of the prospect of success, G, sorry, looking at G, 839G, it seems to me that a question about merits, whether considering merits, only in the most extreme case, either way, the merits of the sense of prospect of success can be relevant to decide whether bringing them separately is an abusive process. The case can be shown to be cast down, so the judgment could be delivered. This might perhaps outweigh factors suggesting it ought to be abused. In these proceedings, we say that The case on liability for fraud is a very strong case because of the findings of the court. And we'll come on to make that submission later about a strong case in fraud is an important factor, we say, in saying that your Lordship should not find these proceedings are abuse. And again, asking your Lordship to look at paragraphs 64 and 65 of the judgment.
Well, this is all what I call fact sensitive. I'm not clear what principle you're citing Stuart Liddell for. What do I get from
What I was asking you to on 65 is that expression in the middle of 65 in the D. A common law must be clearly shown to be an abuse. Clearly, which all should clearly get over the hurdle. And I think that is helpful in that case. And I just asked your Lordship to read paragraph 68 yourself, and we say that the conclusions could be applied here. And finally, I'll make some submissions on.
Yes, I've read that. Thank you.
And finally, Lord Justice Sedley and Lord Justice Clark, giving their judgment, were a bit harsher on the topic, but they both did so on the basis that there was a deliberate breach of all the may put you into trouble. Had to be deliberate. That's Sedley at page 844 and Clark at page 847. And I finished that. I thought it might be a good time to.
Right. Well, shall we take a break now? Thank you. We'll resume at 2 o'clock.
All right.
This would be a great one.
Yeah.